We may have a few others that trickle in a little bit late, but I do appreciate everyone coming out. I know we're in the midst of mass hysteria right now, so I would not have been surprised had I been talking to nothing more than a Facebook Live camera, but so be it, and we'll see how this goes. But I am fully disinfected and fully ready to go, so we will all boil ourselves on the way out as well. But, thank you for joining me. Again, residential sales contract, we've been doing these monthly. Some of you have attended each of them. Back in January, we did the preamble and the real property paragraph. Last month, we went into price and financing and all sorts of elements with the financing contingency. And today, in lockstep, we continue our chronology through deposit, settlement, and down payment, paragraphs 3, 4, and 5. The timing on this, again, I'm not exactly sure if it will take exactly an hour. We're not confined by the restrictions of continuing ahead, so maybe a little quicker, maybe a little slower. We'll try to get you out of here no later than about 1 or so, but do appreciate you all joining in. That's me right there in front of the KW Red. Appreciate you all welcoming us. We had a great time last night at the event for everybody that came. A super time, and just enjoying being a part of the family. I told you when I came on in January that one of the big things I loved about KW was the culture and the family environment, and certainly that's been no disappointment. We have been taking up residence in that office right around the corner, so if you need us, you know where to find us. I also want to introduce Marta Bingham. Marta is newer with MBH. She's been with us for a couple of weeks or so, but she's going to be kind of heading up our operations in your Tyson's Vienna market and here in Arlington, of course with Melody and I's assistance as well. Marta comes to us with about 15 years of settlement experience. Marta's bilingual as well, so should your clients prefer Spanish speaking, we have both settlement agents and processors to assist them. But make no mistake, I love being here. I love feeding you. The goal is to get to the settlement table. It's to work with you all, so we appreciate the support, and certainly we welcome a symbiotic relationship to be able to work with you on your transactional side as well. So, enough shameless self-promotion. Let us get into the body of the contract. I've left this slide in every outline and probably will continue to do so. Familiar faces, so I'm assuming this is not first blush for you, but just make sure you're using the right version of the contract. The revision is down in the bottom left-hand corner of all your contract documents. Residential sales contract, 1219, all your financing addenda, 719. And as sure as we know that today is Thursday, we know that there'll be future versions coming out of NVAR, and we'll update that. Nothing illegal about the old versions, it's just it doesn't do you any good to know what the rights and obligations are if you're using a different template. So just part of your laundry list, your checklist, be sure that that's your track. All right, let's go ahead and get into the meat of it, the deposit paragraph. I realize a couple of these questions are rudimentary, disparate levels of experience here in the room, but is a deposit required in order to validate the contract? Most of the time when people are taking agents along with them, this is sort of pro forma. There is an earnest money deposit that's included as part of the contract. But just so you know, from a legal perspective, it is not a requirement. A valid contract is offer, acceptance, and consideration. And the consideration is the sales price. Just the same as I hire somebody to come out and unclog my sink, I don't have to give them $10 to come out and then the $190 once the clog is clear, right? There is no requirement of a deposit. Generally where we don't see a deposit, however, is only in familial transactions or for sale by owners. I've known this tenant for 10 years, I'm not going to require a deposit to march forward. Certainly from a buyer's perspective, I think this is pretty self-evident. If you're going to put an offer in, particularly in this market without an EMD, you probably don't look much like a motivated buyer, and you're not going to really distinguish yourself should there be a multiple offer scenario. And to the extent you're on a listing side, again, while the deposit is not mandatory, I don't know that I would take a buyer too seriously if they came in without an EMD. So practically speaking, yes, you need one to validate your contract. Legally speaking, it's a no. Okay? How much is often the question as well. I think this is a miss that many agents, an oversight for them in terms of what the deposit is going to be. To me, this is an easy opportunity to distinguish your contract from the myriad of others in the multiple offer scenario. You all know it when you're on the listing side. Sales price is number 1. Certainly if they come in cash, that's number 2. Contingencies is their sale of home, financing, conventional FHA, VA. Then we get into our contingencies like appraisal and financing and home inspection. Are they waiving them? But certainly what we look at, it's real easy because we're flipping the contracts on the second page. What's the deposit? I can catch a seller's attention by putting a higher EMD in there. And if my buyer's going conventional and plans on putting down $100,000 on their $500,000 house, I see no reason why we don't get the seller's attention with a really significant EMD. We're going to be parting with that money 30 days from now anyway. Put it in your contract. Get the seller's attention if you think you're going to have a multiple offer scenario. Your buyer is not foregoing any rights. Putting it in there, it's still insulated, it's still held by a neutral third party. So definitely consider a higher EMD if you're going to try to get the seller's attention. All right. Select MBH as the escrow agent. At the risk of that being self-promotion, select the settlement company. KW has a policy, it will not allow your buyers to hold the security deposit with them as the brokerage. That's good policy. That is policy I helped Shane to implement a number of years ago for a couple of very obvious reasons. The first is the Virginia Agency Code. If you all as the brokerage are the escrow agent, the agency code says it has to be deposited, absent agreement between the parties within 5 business days of ratification. And the problem there, of course, is if you're busy, you're dealing with multiple clients, multiple offers, hustling around, and that check gets tucked in your pocket, and 6 business days after ratification, you take it, you give it to Amy or Rachel or Lisa, whoever it is gets the EMD, well, you haven't been timely. You violated the agency code. Well, no harm, no foul, maybe you think. The problem there is that there's also language in the agency code that your broker has to self-police. That if deposits aren't properly deposited in a timely manner, they have to report you to DPOR, or they themselves are guilty of an agency violation. And so by holding the EMD in that scenario, you put your broker in a very odd position. They either have to narc you out with DPOR, or they themselves have to create their own liability for the brokerage. And it is comprehensive, and of course they get audited and everything else. They have to report you. You can circumvent all of that by having the settlement company hold the EMD, which is why Shane went to that policy a couple of years ago. We are not bounded or constrained by the agency code because we are not a brokerage. So if you show up on day 6 with the EMD, I can just quietly deposit it in my escrow account and nobody's the wiser. Nobody has to report you, nobody's committing any agency violations. Okay? Secondarily, there's the issue of neutrality. You're working with your buyer, you deposit the EMD with KW, your buyer cancels under home inspection, right? And you say, hey, don't worry, we can cancel the contract. You send over your home inspection contingency, or your home inspection report, your notice voiding the contract. Seller says, I'm not letting you out, I'm not signing the release. Well, if KW's holding the EMD, your buyer's staring at you like, Rick, what gives? You told me I could get the EMD, now your own broker is not giving me my money. I thought we were on the same side. It's a bad look for you. Settlement company does, it's real easy to justify it. They're a neutral third party. Yes, we have every right to cancel under home inspection, but the fact that we don't have a release means they can't play judge and jury. And that's an easy out for you without blemishing the relationship they have with your buyer. Again, to take home, any scenario, have the settlement company hold the EMD. KW has a policy against it. All right. Sorry, your formatting's a little different than mine. The question marks in there are just meant to be blank squares. But buyer has delivered deposit to the escrow agent or will deliver the deposit to the escrow agent blank days after ratification. Select the second option, particularly because it's not KW holding the earnest money. So even if you have that check in your possession, you're not delivering it to me on the date of ratification. Don't make your job that much more difficult. Give your buyer a couple days. So even if you have the check up front, check the second box, put 2 or 3 days in there, and that way you can get it over to us. If you need a FedEx, we'll get a FedEx to your clients. We can get them wiring information. We also have a box here in the office. But give yourself a window of time so you're not having to race across town to get that deposited, and always select that second box that you'll deliver. All right, EMD bounces. Can't even read my own writing. So this one's kind of a back and forth here, right? Essentially, MBH is holding the EMD. We get notification this morning, hey, EMD is bounced. We let you know. Keep in mind you have some ethical agency obligations here that are sort of on opposite ends of the spectrum. The first is good faith, fair dealing, truthfulness to all parties to the transaction. So if you're the selling agent, that includes the listing agent who thinks that the EMD has been deposited. You've also got an agency obligation to promote your buyer's best interests, and those interests certainly are not benefited by you telling the listing agent that your own buyer's check bounced, right? Confidentiality as well, right? Anything detailing dealing with your client's finances, it certainly falls within the confidentiality. And it didn't bounce with you, it bounced with the escrow agent. So you've got all these different things sort of wrestling with one another in terms of what your obligation is. To me, the best I can do with this is get on the phone immediately with your buyers. I don't think you rat them out right away, and I don't think you have an agency obligation to tell the other side right away. Communicate with that buyer, let them know this check bounced, we need to get that money in there immediately, right? And we need some sort of good funds. You need to wire it, you need to get a certified check to the title company. Are you going to be able to do that today? Because 9 times out of 10, the buyers had the money to begin with. They picked up the wrong checkbook, right? Or money got wired in and out of the wrong account, or whatever it was an honest mistake. And they can rectify it almost immediately. And to me, there's no reason to go and tell the other side that they did something to breach the contract, right? I don't think you have that core agency obligation that you have to do it, right? It's much the same as if you're sending over a home inspection report a day late. If the other side says, that's fine, we'll negotiate it, I don't think it's your responsibility to tell them, hey, just keep in mind, I'm sending this over after the deadline. You'd be in a better situation if you didn't let me negotiate this, right? Your job is to promote your client's best interest. At the same point, if it's something more pervasive, if they're like, yeah, you know, things got sideways on me, I need to sell some securities, it's actually going to be a couple weeks before I can get that earnest money over to the title company. Well, at this point, I think you've got this duty of good faith. You've got to reach out, first off, to your broker. You're welcome to give me a call, and it's situation specific, but ultimately, I think you need to alert the listing company or the seller that EMD isn't there. And the title company eventually is going to have to make that disclosure anyway, so they make the job easy for you. But try to peel that onion a little bit to see. But I don't think you just reach out immediately and say, hey, my client's check bounced. Rick?
I've heard of one title company, they stopped taking personal checks. It's only a wire or money order.
Got it. Yeah, I mean,
because even after it's deposited, it could still be recalled.
Yeah. Well, and even still, I mean, that can be the case, yeah, with a certified or bank check as well. You know, in this day and age, fraud seems to be kind of leading the discussion. There was this window of time a number of years ago where we wouldn't take checks because all the checks could be fraudulently created. And so we'd say, oh, only take a wire. Now wires are so dangerous because of all the fraud elements that some title companies are saying, well, we don't want wires anymore, we'll only take a check. So it's 6 of one, half dozen the other. We're happy to take a personal check. Now, if it's an EMD of $100,000 and they're closing 2 days from now, clearly, you know, the title company does need to protect itself. So you've kind of got to, it's got to pass the smell test. But your typical scenario where you're 3-4 weeks to settlement, personal check for $10,000-$20,000 is fine. We will take cash. Keep in mind that your clients we'll probably meet them at the bank. And if it's over $10,000, we have to report the cash to the IRS, which usually somebody smuggling that much cash, there's a reason. And they don't want us to report it to the IRS, so they may want to do something with that before they get our direction. You know, this is just one to mention to your clients, particularly if you have a larger EMD. It's once a year I have a client that gets sideways about not getting interest on their EMD. The contract says the deposit may be interest bearing, but the parties waive their rights to it. So if you've got a high dollar client putting down $250,000 and settlement doesn't occur for 4 to 6 weeks or something like that, make sure they understand that there's no interest that they're going to get. If they want you to explore that with the title company, there are oftentimes fees associated with setting up the interest-bearing account, and with current interest rates, it's probably not going to make much off it anyway, but it's just something worth mentioning if your clients are putting down a high EMD, that they understand they're not going to get their couple bucks worth of interest out of it. How's the EMD released? Sort of a more substantive conversation, and it's one we talked about when we did our contracts class back in January, but I think it certainly bears repetition because it's something I hear all the time. Our settlement is scheduled for today, 12th of March, and of course the lender calls and says we need a couple more days. And the seller, scheduled to close today, scheduled to move out, all this, says we still want to come and we want to sign our paperwork. And of course their discussion evolves. They're sitting there with their listing agent and they're trying to get all the facts straight, and eventually we all have the same tendency, which is to worst case it. Right? So they say to their listing agent, well, what happens if the buyer ultimately can't close? Right? And the version of things that I hear more often than not from selling agents from listing agents is, we'll take their deposit. This sort of conclusive statement that it's out there and at our discretion we can put our hands on it. Right now, the bird in hand, the best case, is to close because we want the whole sales price. But if we need to at any point, we can take that $5,000 or $10,000 EMD. So Seller kind of gets some solace from that. No problem. All right, let's see where this goes. Right? And of course, worst case scenario ends up transpiring. You wait a couple days and that small lender issue becomes a big lender issue. And you wait a week and they start to get impatient. And eventually, of course, they call the bluff and they say, hey, you know what, I was thinking, I don't want to do this anymore, I want to take the earnest money. Right? And as we all know, there is no easy way to simply take the earnest money. We don't have that luxury. We don't have that choice. Paragraph 3 is real specific in terms of how an earnest money deposit can be released. The first is that it's credited towards the sales price at settlement. Well, of course, we didn't take their earnest money, they gave it to us. And they gave us a whole lot more than that earnest money. They gave us their entire down payment, their loan proceeds, and everything else. We didn't take it. All parties have agreed in writing to its disposition. Again, we didn't take it, but we all agreed bilaterally, buyer and seller, we signed a release, and we said this is where it's going to go. Right? So if we did end up getting it, we didn't take it, the buyer gave it to us. 3 is a year down the road, we hired an attorney, we went through court, all appeals periods have expired. And maybe that's a win, but it's far from taking it. It's a court awarding it. Right?
And it takes a while.
It takes a while. Right? And it's usually going to result in some sort of a judgment where we may get the EMD, and any kind of other judgment's just going to get recorded in the land records, and we hope down the road we're able to collect on all of that. And 4, you might as well line through. Because while there are statutory means to release an earnest money deposit in the real estate world, they're really not relevant. So you've essentially got these 3 elements. Did we close? Did we sign a release? And did we go to court? So of course, none of those has anything remotely to do with taking the EMD. And so I think it's really critical that you set realistic expectations when you're sitting with your sellers. And point out to them, well, it's not an easy means for us to be financially compensated. We do have the contractual high ground, but it's not as easy as just reaching out and taking that earnest money. And of course, the immediate reaction, of course, from the seller is going to be like,
What's the point
that
of the
sucks, right? How'd you get me into this lousy situation? And to there I reference them, and where you want to take them then is paragraph 28, which is the default paragraph. All right? And the default paragraph is specific. And it says, if we as sellers gave you a release and a court finds that you should have signed it, and in this case it's clear as day, where after the settlement date, the seller had performed, the buyer failed to perform because their financing wasn't in place, right? Buyer is clearly in default. They should have signed the release, they should have forfeited the EMD. If I take them to court, right, in addition to any other award, all of my expenses, including my attorney's fees, right? So there is a means, if the buyer doesn't sign the release, there is a means for us to go after them for the earnest money. And if we have to hire an attorney, we are awarded attorney's fees as well. So as I say, the cost of being stubborn can be really significant. Right.
So if a deposit is tied up and the buyer's not signed a release, can the seller still accept another contract?
Great
or-
question. Yeah, and of course this is the reality, right? When we talk about practical implications here. Buyers have this expectation that says, well, I may have breached the contract, but my ace in the hole is that you need to sell your property. Number one, I'm your highest and best use. If my lender's saying it's going to only be a week, well, I'm the much quicker path to getting paid than putting it back on the market. And secondarily, if I'm not going to sign a release of contract, how can you go forth and sell it to someone else? And so in this scenario, to me, the important thing to do is have a heart-to-heart with your seller. First, of course, propose the release. If they want to cut ties with this buyer, right? If they're saying enough's enough, I'm not willing to wait any longer, or just out of spite, I don't want to sell it to this buyer, they have every right to do so. Buyers fail to perform, buyers in default, right? But have the discussion to say, we can't just take the earnest money, right? We can hold up that earnest money. Absent a release, though, we have to take some action, right? Number one, Virginia has an obligation to mitigate your damages. So what I absolutely, as a seller, cannot do is to say, will you sign the release? No? Fine. I can wait all night. I can wait all year. And 2 years from now, I say, hey, I'd like to sue you for 2 years of my damages because I could never sell my home. A court's going to say, you as the seller had an obligation to mitigate your damages. We're not going to let you just sit back for 2 years and collect your carrying costs and storage and everything else. You could have made this a better situation. But what you don't want to do, of course, is to agree to sell the same property pursuant to two contracts to two different buyers. And if you've still got one in place with buyer number one, how can you with buyer number two? And so in this case, if your seller wants to proceed forward, they still want the EMD, buyer won't sign a release, but they want to get the property back on the market, I recommend they hire an attorney. Because the attorney is going to take the crosshairs off you in terms of liability. The attorney's going to send a letter to the buyer detailing the contractual position, detailing the Virginia obligation to mitigate their damages, right? Offering them again a solution to sign the release, right? And then they're going to be able to counsel your buyers or your sellers how they can put the property back on the market.
It's the exact situation happened to me last summer.
And you can take it into your own hands. If you don't want to hire the attorney, you can put it on the market and say in your comments, subject to obtaining a release from existing contract. And when you ratify the contract with buyer number two, you can say, closing of this is contingent upon obtaining a release from a contract dated March 12, 2020 with Rick Boswell. But that's going to dilute your pool of prospective buyers. And in this market, maybe it doesn't matter. Maybe you had 10 backup offers anyway, and you say, we're working this out. If you'll sign this contingent contract, you don't need to hire the attorney. You have your contingent contract. You're able to work on both because you don't have to close with number two until you deal with number one. But if you don't want to dilute that pool of buyers, you were on the market 60 days anyway, and we got to get this thing back on the market, I recommend you hire the attorney because then you don't have to dilute, you don't have to have all that language in there. You can still move forward and sell to buyer number two.
What if some in the language of the contract made it void, and the party still won't sign a release, and if the contract is void, can you accept another one, or?
Well, void is a truncated version of void ab initio, which is a Latin term as if it never happened. So if we void a contract, right, we void under, home inspection. That's a buyer voiding, but they won't sign the release. Well, if we know definitively that the contract is void, then it's as if it never happened. It's all irrelevant. We're just fighting over some money. But maybe they're saying you didn't void because you didn't properly deliver it. It came over after the deadline. Usually there's some sort of good faith argument. And in this case, it's not that the contract was ever void, it's that the buyer didn't close. So you still have a very valid contract with very real rights and obligations. You just have a buyer that breached that contract, so it's not void. And so in this situation, you still very much have contract number one in play. So a nuanced discussion, and I'm happy to have it with anybody on a case-by-case basis because it's all predicated upon what your seller really wants. Are they going to take this thing all the way to court if they have to? Right? What's the leverage they have with other prospective buyers? Is this a hot property? Can we market it subject to release? Do we just need to move on? Like, what's the EMD? Are we going to sue them for damages? Like, it's a nuanced discussion, and that's why I say it's important to bring an attorney into the mix because it takes all of the burden off of you, right? And that's a benefit for you in this scenario because eventually, if it doesn't get worked out, there's going to be an attorney in the mix anyway, so you might as well have had him with somebody from the get-go, and that way you don't have any opportunity for any missteps.
This may be a very ignorant question, but do you have an idea of like attorney costs and where to get one?
I mean, if you're taking it all the way to court, 5-10 grand, somewhere in there. So, I mean, if you're just hiring some small-time practitioner and you're fighting over $1,000 or something like that, maybe 2,000 or something like that. Just depends upon how significant it gets. So, but to give you a very real example, to kind of take this the next step further, because I think it dovetails in with your question, buyers will sometimes ask the question, right? Well, I'm starting to feel a little edgy here. What's my worst case scenario if I can't close? Or the buyer with cold feet says, I don't have any other way out, I just don't want to buy the house. What's my potential liability? And of course the misstep for the selling agent is to say, well, if you breach the contract or you don't close, you could lose your EMD. And in no way do we ever want to tether a buyer's expectation of liability to their earnest money. Because the contract is very clear that it's not the extent of their liability. The deposit paragraph states that if they breach, at the option of the seller, it could be forfeited. Right? So the seller says, I'll sign the release, I'll let you go, it's 5,000 EMD. You agree to part with that 5,000, we'll go our separate ways. But if the seller does not elect to accept the deposit as damages, it may not be the limit of buyer's liability. And in your question, I always reference the case Sandbeck v. Reyes. Sandbeck versus R-E-Y-E-S, Reyes. Ms. Reyes was a young attorney, hotshot who backed out of a contract and refused to sign a release of $10,000. And the Sandbecks owned a house down in the southwest quadrant of Old Town, had to put the property back on the market, had to hire an attorneys. Ultimately, by the time they sold it, they had significant loss, carrying costs, storage costs, attorney's fees, dilution in value because they couldn't sell it at the same point because the market had dropped a little bit. And they sued her, and ultimately the court awarded a $78,000 judgment against Ms. Sandbeck, or excuse me, against Ms. Reyes in favor of the Sandbecks, right? So a $10,000 EMD turned into a $78,000 judgment. And so that is very illustrative of how significantly bad this scenario can get for a buyer that just chooses the tact of saying, well, what are they gonna do, sue me? Right? Yeah, they might. They probably won't, and take some solace in that, but there is something to be said for being able to cut your losses on this. Any buyer that says to me when they can't close, they say, well, what's my potential liability? I have no idea, right? Because I gotta fast forward and look in my crystal ball to see what happens when the seller actually sells the property, right? And they've got a 4-year statute of limitations in Virginia to sue you, and by the time we get into broker commissions, attorney's fees, carrying costs, right? That could be really sizable, $78,000 in Ms. Sandbeck's. Ms. Reyes.
So I don't understand this sentence at all, because it says if the buyer fails to complete for any reason other than default by seller, but what about your contingencies, or is that
Yep.
because they're contingencies separate pieces of papers?
Right, so your settlement obligation is predicated upon still having the contract in place. Remember, if we void, the ways that we can void, like FHA, VA, low appraisal, home inspection, financing falls through and we deliver, right, our written rejection letter
Those
for our
are
specified
outside
financing.
things.
Those all void the contract. And so this all becomes irrelevant because the contract no longer exists. What we're assuming here is, of course, we've gotten to the settlement date.
Uh-huh.
The contract hasn't been voided, and if closing didn't take place for any reason other than default by the seller.
Gotcha.
And what that's meant to capture is the fact that the lender effectively is on the buyer's side, right? Buyers have to realize that as well. Buyers think, if I do everything right, but I can't close because I picked a crappy lender,
Yes.
then I should be forgiven for that because I did everything right. And that's not the case. The seller can take that argument. The seller says, I did everything right. You chose a poor lender, you can't close, that's on you. So anything other than the seller not performing, the buyer's gonna be in default, right? Buyer has to get to settlement date, sign all their paperwork, tender their funds, otherwise they're in default under the contract, right?
Thank you.
Yeah, of course. All right, changing gears. Paragraph 4, seller and buyer will make full settlement in accordance with the terms of the contract on or before, and that's our settlement date. So that's our contractual language. So we've got this language here. On or before our settlement date. So my question, if the buyer wishes to close prior to the settlement date, must an addendum be signed? Right, so we've agreed we're gonna close, whatever, the 31st of March. Everybody says, hey, can we move it up a week? Yeah, we're all in agreement. Do we have to sign an addendum?
Yeah.
No.
No.
A little bit of both, and I like your answer, Dale, because I think ultimately at the end of the day we want an addendum signed. Contracts language says on or with mutual consent before. So if we've agreed to close, we don't necessarily need, we've already said we'll close on or before the 31st, we close on the 24th, everybody's in agreement, an addendum was not required. That being said, if we agree today that we're all gonna close the 24th, but yet the contract says the 31st, no addendum is signed, and we get to the 24th, and the buyer says, yeah, I was thinking about it, I actually do want the extra week. Well, we have nothing to fall back on, of course, without an addendum, because the contract says on or before the 31st, I have every right to push it out to the 31st. So, Del, I think everybody's on the right track. If you're gonna move it up, even though the contract allows you to do so, you wanna have an addendum to say, let's go ahead and formally say we're gonna close the 24th, because that's, I'm putting my eggs in that basket, and I need to make sure that that's ultimately when we do close. All right. What constitutes full settlement in accordance with the terms of the contract? So we said we gotta make full settlement in accordance with the terms of the contract on or before this date. So what constitutes that full settlement? Paragraph 27 is our performance paragraph. So we've gotta satisfy all the rights and obligations in the contract, plus we've gotta perform. And the performance paragraph of the contract has 2 elements: delivery of required funds and executed documents to the settlement agent. Both of those constitute full performance, and we know that we have to have full performance on or before the settlement date. So where this warrants discussion is applying Virginia common law versus what's called a literal constructionist approach. Literal constructionist, which I tend to be more in that realm, says you look at the four corners of the sales contract, and if you can make a determination of what the rights and obligations are, you don't look any further, right? What does the contract say? And the contract says, in order for me to establish full performance, I have to deliver my documents, and I have to provide funds. So we get into a couple of different scenarios here. Split settlements. Split settlements are pretty common in this day and age. We're going to talk about them, but essentially there's a settlement agent who represents the buyer, and a separate settlement company or an attorney who represents the seller to have them facilitate their settlement obligations. But there's only one settlement agent. Settlement agent is defined in the contract. It's chosen by the buyer. How do I perform under the contract? I deliver my funds and I deliver my executed documents to whom? The settlement agent. So Virginia common law doesn't want to discourage any party from having separate representation. So Virginia common law would look at me as a seller. If my settlement date is today, March 12th, I sit down with my settlement attorney, I sign my paperwork that I have effectively performed. Right? The problem is, have I delivered my documents to the settlement agent? It's sitting there with my attorney, but I'm separately represented by a seller. The settlement agent is the company that's handling the transaction on the buyer's behalf. So definitively, I have not yet delivered the documents to the buyer, to the settlement agent. And if you take this literal constructionist approach and you say, in order to perform, I as a seller, I'm not upside down, so I have no funds, but I haven't delivered my executed documents to the settlement agent. So have I performed? And I would say from that constructionist approach, you haven't. Does the settlement agent have it? No. Clear as day. You may say, well, common law, you're confusing me here a bit, Ryan. Where this is relevant, buyer's meant to close today on the 12th, right? That's the settlement date. The seller goes to their settlement company, they also sign on the 12th, and the settlement company says, okay, we'll overnight the documents to the buyer's title company, and that gets there on the 13th, right? Has the buyer performed on the 12th? I mean, has the seller performed on the 12th? No, because the settlement company doesn't have the documents. Buyer's financing gets sideways, and they don't end up closing on the 12th either, right? And you fast forward a week or two, and now the seller wants blood. The seller says, I want to sue the buyer for non-performance, and I want the earnest money or my damages or everything else. And everybody lawyers up. And any time that somebody lawyers up, the first thing that we're looking for is, was there a contract in the first place, right? Was there not a meeting of the minds? Did we miss a signature initial? Where can we create doubt that there was no contract? But then secondarily, did everybody satisfy their performance obligations? And if I'm representing the buyer in this scenario, the argument that I'm going to make to protect my buyer is mutual breach. That yeah, the buyer didn't close on the 12th as required. But you know who else didn't close on the 12th? The seller. They signed everything on the 12th, but they didn't deliver their documents to the settlement agent before the settlement date. They got them there on the 13th. And because both the buyer breached and the seller breached, you know what? There's no liability.
But the buyer only breached because of the seller.
Well, no, I'm saying like the buyer, their financing wasn't ready,
Oh, okay.
right? The buyer breached in the general sense that we all know buyers breach, right? Because their financing is ready. The seller did everything required of them, but they signed on the settlement date, and their settlement company didn't get the documents to the settlement agent until the day after. And so now as an attorney representing the buyer, I'm creating doubt. I'm saying, you know what, feel free to sue us. We're gonna sue you right back because you didn't perform either. And what we'll agree to do is just sign a release and have the buyer get the EMD back. And what that is a really, really long and confusing way of telling you that if you are doing a split settlement, make sure that your settlement company can get the documents to the settlement agent, the buyer's settlement company, on or before the settlement date. And if that means you and your sellers need to sign a day early, sign a day early. If it means you need to pay them to courier it across town, have them couriered across town. Right?
Do they have to be live?
What's that?
Can they not be emailed?
Well, so a deed, an executed settlement document, right, needs to be an original deed because that's what you have to record in Virginia. So arguably, if I haven't delivered an original deed, have I performed under the terms of the sales contract? And again, Virginia common law would wholeheartedly support that a buyer who signs on their settlement, or seller who signs on their settlement date and delivers documents the next day has performed. It's just we don't want to put our sellers in that position in terms of performance. So I recommend anybody doing a split settlement, have your seller sign either the day before,
Okay.
or make sure with your title company that they can get the documents there same day. Because what I don't want to do is to expose my seller for potential liability for doing exactly what they probably should have done. Does that make sense?
Yeah.
Okay. The flip side of that argument is buyer mailaways. We're seeing a lot of buyers that can't attend settlement. If it's a cash deal, who cares? They can sign everything well in advance. We can even get electronic signatures. There's nothing that needs to be recorded on a buyer mailaway. But if a buyer's getting a loan, the lender is going to require that they sign documents only on the settlement date. And if I'm signing on the settlement date out in California, obviously I can't deliver the settlement documents to the settlement company on the settlement date, because I signed them today, overnight, and they get there tomorrow. In this case, just make sure you get the seller's consent to do so. Because while your buyer is arguably performing under common law, they're not performing under the terms of the sales contract. And you don't want the seller to try to create liability because of that. And it's going to have a financial impact upon the seller, because if I close today, the seller gets their money this afternoon and their payoff goes out today. If I don't get the documents till tomorrow, that's at least a one-day delay. So just be sure you've run that by the seller. All right? Also, time is of the essence. It means we choose a settlement date, that date matters. Everything has to be done on or before that settlement date. We see this with like home inspection remedies, right? Seller says, I'll do these 10 things, one of which is actually going to be done the day after closing. Time is of the essence means that deadlines matter. Failure to meet the stated dates and timeframes will result in a breach or default under the contract. So I, as a seller, if I do 9 other things and have one that's going to be done the day after closing, I have not performed under the contract. I haven't satisfied all of my settlement obligations, and a buyer would be well within their rights to say, yeah, I'm not buying it. So keep that in mind when you're trying to satisfy all of your contractual requirements, right? Particularly home inspection, that you could be giving a buyer an easy out, right? If it's going to be a day after, send them over an addendum and say, hey, buyer consents to the chimney being swept the day after closing. And that way, ultimately, if the buyer can't perform, they can't look to the seller's mutual breach as their way out to avoid liability. All right? The day after doesn't carry the day. Settlement day falls on a Saturday, Sunday, or legal holiday. Settlement will be on the, what's the boilerplate? Prior or next?
Next.
Prior.
Prior.
I know.
That's what I meant.
I always think next too, because it makes sense, right? It shouldn't push to the day after. It's the day prior. That's just in the body of the sales contract. You know, everybody's got a calendar on their phone. It amazes me sometimes. I'll get contracts in and like closing is to be December 25th or something. I'm like, really? Right? Like, just look at the contract, just make sure. But if it falls on a Saturday, Sunday, or legal holiday, always it's on the day prior.
Well, yeah, like, that happened to me, we had an offer coming on MLK, and everyone's like,
Yeah.
and they refused to move it prior, they're like, we move it to after, we won't have the lend financing group.
Yeah. Well, in that case, the buyer would have been in default for closing on the Tuesday afterwards, because the contract automatically goes to that Friday before. And so it's just, reference point there. Buyer's choice of settlement agents is in paragraph 4, RESA, the Real Estate Settlement Agents Act. You have the right to select a settlement agent to handle the closing of the transaction. That is a unilateral right in Virginia for the buyer. Further, there's language in the Act and in the sales contract that the buyer's rights can't be augmented by separate agreement among the parties and can't be waived. Meaning that if I sign a contract that says I'm going to use ABC, and then a day or a week later I say, well, you know what, I'm going a different direction, I'm going to use MBH. There is nothing that a seller can do to require me, even though I agreed in a contract to use ABC, there's nothing a seller can do to hold my feet to the fire. I have every right to change my mind. That is a unilateral right in Virginia to be able to use the settlement company of your choice. We see this come about in a couple of different ways. I mean, the first is, of course, the seller says, I want to use ABC, right? The buyer says, well, it's not usually who I close with, but it's multiple offers, so I'm going to go ahead and agree. And then you just get a bad feeling, right? A week goes by, you haven't heard from them, you're trying to track down somebody, you get no communication, everything has gone completely sideways, and you think, well, I'm not going to continue this. I'm going to move it over to MBH where I know things are going to go smoothly. So that's one way. Buyer has every right to do so. Then we see buyers, I think, that take the tact of getting their contract through, knowing full well that they're going to switch it, right? Seller prefers ABC. Well, I'll use ABC now, and then the day after closing, or the day after ratification, sending over notice, settlement agent is hereby amended to MBH. Every right to do so. There's really nothing a seller can do in that scenario.
That kind of happened on one of, like bank loans, right? They'll often require the seller to use their closing company, but we can sign the contract just to get it through and get it approved and then switch once we're under contract.
Yeah, and I mean, we've seen an evolution of this. Early on with REO deals, when they first sort of came about in 2009, 2010, and so the banks were far more draconian in terms of what they require. You have to use this, these are your rights, we're not gonna get you HOA or condo documents. It was like they were making up their own rules.
Yeah.
And it was sort of this scenario of like, well, you can fight it or you can just get to sell. Most banks, their REO addenda will provide some sort of incentive
Yeah.
to the buyer for using them, kind of like a new construction. Use my title company, use my bank, and we'll give you we'll finish the basement. Most banks now don't obligate you to necessarily do it. To the extent that they have it in the contract, again, you could change it after the fact, but you may be dealing with an asset manager who says, well, sue me. It's not my house, my liability. You signed a contract that said ABC. That's where we're gonna close.
I see with reload companies too. And these big long addendums
Yeah.
saying you have to use this settlement company.
Yeah, yeah. I mean, certainly a buyer is every bit within their rights. There's plenty of precedent and legislature to suggest that a seller may not condition the use of a certain title company. Under Virginia law, under the Real Estate Settlement Procedures Act as well, if the buyer is getting a federally backed loan, then there's treble damages assigned to a seller who requires the use of a certain settlement service provider, so you could go after them for significant liability, but much like that EMD discussion, sometimes that contract's only not even worth the paper it's printed on.
So you can just switch with a notice, it doesn't have to be.
Exactly. Yeah, doesn't have to be an addendum that's agreed upon by the parties, so. All right. Buyer designates, a little more shameless self-promotion there. We'll leave that up for a while. Okay.
Best slide.
No, I mean, honestly, I hear stories from time to time, agents that have done a lot of business with us will come and say, oh, Ryan, you wouldn't believe what happened. I used ABC, it was terrible, they were in a strip mall out in Loudoun, and, I didn't get my commission for 2 weeks, and believe me, there is not 1 ounce of sympathy that I have for you. I love those stories. Like, I say, keep it coming. This is great. This is like a lullaby for me. I want your experience to be as bad as it possibly can be, should you need it.
Not the evil.
That's right. Split settlements. Again, we discussed the buyer's unilateral right to choose their settlement company. A very, very commonplace in Virginia, of course, is for the seller to maintain and seek their own separate legal representation. Certainly no issue whatsoever in doing so. I think if we fast forward 5 years or so, probably 90% of our closings, we will see independent settlement companies representing each side. The reality is parties just have their own comfort levels, and there really is no reason to all close under the same roof. Split settlements are very, very common. From a contractual perspective, we looked at it previously. Buyer designates, buyer identifies the settlement agent. That's the contractual term. In Virginia, there's only one settlement agent. Even if the seller is working with another settlement company, there's only one settlement agent. And that's who orders the title search, who takes in and disperses all the funds, who records the deed. They are the settlement agent, whether you have a split settlement or not. So from a contractual perspective, buyer designates, right, MBH. Perfectly fine. If your seller is going to split and go elsewhere, they don't need to have anything at all in the body of the contract. It's not a negotiable term. There's nothing that this buyer can do to require the seller to close with the settlement agent because because the seller is closing with the settlement agent. It's just they're seeking their own representation. And that's the dynamic of this split settlement. So if you want to pen and ink something right up in here like I see a lot of agents do, right? Buyer designates ABC, seller to use MBH. You're welcome to do so, but you don't have to. If you want to put it in paragraph 41, other terms, seller to close with MBH. Have at it, but you don't have to. You're perfectly within your rights to ratify the contract and then just send over an email after the fact. Hey, by the way, my seller's gonna split, my seller's gonna use MBH. You don't need the buyer's consent to do so. It's not a contractual term because you're not changing who the settlement agent is. All right? Guys, I would encourage you on every single one of your deals, if you don't love the company that the buyer chose, split the settlement. There is absolutely no reason on earth, other than perhaps what you view as convenience, to close with the same title company. It's just not advocating in the best interest of your seller, right? There's a reason the buyer and their agent want to close at a particular title company. There's a reason you don't close there, right? You're closing in the lion's den. There's accountability. You've probably all experienced it on the listing side in the past where you go in and you feel like a second-class citizen, right? And it's real simple. They've never worked with you before. They'll never work with you again. They don't care what you think about their service, right? Further, they have a great relationship with the buyer's agent. That relationship probably has pre-existed. It may be some sort of financial benefit or business interest or something like that, right? Who do you think is going to get the better shake if there's a problem, right? And you should be getting the better shake with your title company. I mean, we are definitively a neutral party, but you can bet if I'm handling your side of the transaction, we're going to look at things in the light most favorable to you and your clients, and that's just reality, right? That's why people choose their certain business providers. Accountability, familiarity, and convenience, right? You've been with that company before. Why aren't you continuing to perpetuate that relationship? To the extent you need a favor, a reduced cost, you need a settlement late, you can ask them, right? Because you've done 20 deals with them in the past and you'll do 100 with them in the future. Why would you close with somebody in a strip mall in Loudon that you've never worked with? They're not going to do squat for you, right? Further, your seller gets independent legal representation. Like that in and of itself is almost a reason, and it's free, right? The buyer's got their own settlement agent. Your seller is represented by my law firm. So if things get sideways, guess who's already in your corner to advocate on your seller's behalf? And then pursuant to Virginia legal ethical opinions, it doesn't cost your sellers any additional money. There's an LEO on point that says if a seller seeks independent representation, the buyer's title company is prohibited from charging them any fees that aren't agreed upon in advance by the seller. So you're not going to show up and get hit with a $500 settlement fee for something they haven't agreed upon.
Where's that?
It's a Virginia legal ethical opinion. I can get it for you if you would like.
You said LEO, I didn't like that.
Yeah.
Because there is a title company that did that. We were doing a split settlement and they had the $500 fee.
Yeah. They're not permitted to by law. I've got the email that I've sent out a dozen times in the past explaining to them why they're violating Virginia law in doing so. And should we have to pursue it, we'll pursue it. Generally what we will allow them to do is no more than a $75 de minimis charge for lien release, courier, and delivery. Because to me, that's equitable. That's what they're doing. If they're gonna wire out my client's funds, that does cost them money. My client should have to pay $25 for a wire charge. Now, if they're gonna get a check, maybe it's $1 for a stamp, right? Anything else they're doing in the interest of clearing title, they're doing that for providing the title insurance on their buyer's behalf. Okay? So it's the same exact fee structure that they would pay otherwise if they were a seller on a full deal. That's what they're paying on a transaction. So again, I don't want to get too far on the soapbox, but what I want you to realize is your transactions are going to go better if you've got your settlement attorney in your corner versus you're in some company you've never worked with. So again, that asking me for sympathy when you're forced to use a company. Well, you're not forced in Virginia. Split the settlement, go with where you're comfortable. I just want to point out that this obligation is in paragraph 4. Buyer agrees to contact the settlement agent within 10 days of ratification to schedule the settlement, right? It's not the buyer that's going to do it, of course, it's the selling agent. And if you sit on a contract for 2 weeks and ultimately there's a title issue that can't be rectified by the settlement date, normally that would be the seller's problem. They can't provide marketable and insurable title. But if they pose the question to the settlement company, like, you've had this contract for a month, why are we just finding out about it now? Settlement company says, actually, we just got it 2 weeks ago, right? That's liability for the buyer because they didn't get the contract. The buyer is now in breach for marketable title that the seller can't provide on the settlement date. So just be sure that you understand your obligation as a selling agent is to get the contract to the title company, right? And the sooner the better. Please don't wait until after your past home inspection or HOA or condo or anything like that. A cost of doing business for any reputable settlement company is if your file cancels, parties aren't going to be charged anything. So don't think you're exposing them to liability by sending the contract over. We would rather have the benefit of time, because then if there is a problem, we can get everything resolved for you. Okay? If you're on the listing side, don't think you're insulated from issues here, right? Your goal is to get to settlement. So if you ratified 10 days ago and you haven't heard a thing from the title company, reach out to the title company, find out what's going on, make sure they've gotten the contract, everything is moving forward. You'll be contacted, our company contacts our processor contacts listing agent and selling agent within 24 hours of receiving the contract to provide an introduction, schedule settlement, and everything else. Like if you're not getting that contact, you need to reach out on the listing side. All right, home stretch here. Paragraph 5. Balance of the down payment will be paid on or before the settlement date by certified or cashier's check. And just remind your clients, again, it's in the contract, it's in all of our introductory paperwork. I know the lender says it, I know you say it, but I've still got somebody once every 6 months that shows up with their checkbook, right? I'm like, ugh, right? We cannot by law take a check that we're not prepared to actually pay, but we have to have good funds in Virginia. So our threshold in most title companies is $1,000. The only caveat there is, of course, if the check bounces, I can write a check to cover the transaction, then follow up with the buyer. That's why we set that threshold. But you got to get good funds in Virginia. All right? So remind them, certified or cashier's check payable to the title company, or bank wired funds. It's worthy, again, of the reminder. One of the very first emphatic conversations you have to have with your buyers and your sellers is that of fraud in this industry. We don't go a week without getting some sort of bogus email or without someone telling us a story of woe. I mean, it is so much more pervasive than you would ever anticipate. And the reality of it, too, is that you all are right at the center of the web. And not by any malfeasance, but if I'm buying with you, nobody knows I'm buying. Nobody's gone out and hacked my email, right? The title companies pay hundreds of thousands of dollars for firewalls and security emails and everything else. So it's not our email that gets hacked, right? But everybody can go online and find houses for sale and start checking out what your email address is. And they see it's, ryanhstuart@gmail.com, and they start watching. They find a way in. I have no idea how, but they find a way in, and they start watching your email as the realtor. Sure enough, they see that you're communicating with me about a closing that's going to take place in a week. And then they create another email. Instead of Ryan H. Stuart at Gmail, Ryan N. Stuart. And it looks just like it, right? And they say, hey, I just talked to the title company. You have to wire your funds, and they actually need it today. So I've given you all the information. Call me if you have, or email me if you have any problems. I'm going to be out of pocket today. And the money's gone, right? And it all circles back to your email having been compromised. And you didn't do anything wrong other than the fact that you didn't tell your clients, if you get anything that has to do with wiring money, stop. Press pause, pick up the phone and call me. Or call the title company, right? Whatever you're doing, you have to take a belt and suspenders approach, because I promise you, whatever level of significance it is, it's 10 times worse. Like, it is so pervasive in our industry right now. And the only positive is that it's become so pervasive that we're all talking about it. Like 2 years ago, it was really dangerous because everybody's like, oh, what's this? This is kind of new, right? And so nobody was having a conversation. But you have to have this conversation emphatically with your clients, or you're leading yourself to potential liability. Okay. All right. And then an assignment of funds. This is in paragraph 5 as well. Shall not be used without the prior consent of the seller. Assignment of funds means I'm selling my property, I'm using the money from that to buy another one. But there's not a significant enough lag time in between those transactions for the title company to send me my money, it seasons in my bank, and then I get a check and I deliver it. Right, they're back to back. I'm selling at 10, I'm buying at 11. And so the money's never gonna go through my hands, but it's gonna be transferred from one file to the next, or from one title company to the next. And so I direct ABC when I sell to say, hey, I irrevocably authorize you to sign all my proceeds over to MBH for my purchase, right? And then the buyer shows up at MBH for their purchase, and they don't have any money, they just got a letter. And it says money's coming. Don't worry, it's coming. And it's called an assignment of funds. And we're perfectly okay in Virginia to close upon that, right? Perfectly fine, no issues with financing, no issues with the title company, but it requires the seller's consent. And it requires the seller's consent because if I sell it at 10 and I don't have money at 11 to buy, I'm probably not going to record that day. And if I don't record that day, the seller's not going to get their money that day. And their payoff's not going to go out that day. And that costs the seller some money. And so you need to get the seller's consent if you're gonna do that. This doesn't set up any sale of home contingency or coinciding settlements or anything like that. This does not protect the buyer in any way if their sale falls through. If you need that, then you need to use contingencies and clauses. This is just saying money's coming, right? And this would be the only language that you would need in your contract in order to get that.
Are there any
seller's consent.
problems using the assignment? I mean, do you ever see it not happen?
No, but what I will see is it's oftentimes more of a lag than we anticipate, right? Like, I'll use Redfin as an example. Their chosen title company's up in Philadelphia, right? And so the seller sells their property today at 10 o'clock, and they're gonna come over to my office and buy at 11, right? And though they sold at 10, maybe their buyer moves things back, and their buyer doesn't buy until 4 o'clock this afternoon. And that individual was probably some traveling notary, and they don't get the documents, they don't do anything with it today because it was close of business. So they send the documents up to Philly tomorrow. Philly gets it, but it's too late tomorrow, so Monday they record, but they're in Philadelphia, so I don't get the money till Tuesday or Wednesday. And so something that closed today on that follow-up transaction with the assignment of funds, your sellers are sitting there being like, where the heck's my money? We closed Thursday, it's now Wednesday. This cost me 6 days worth of interest on my mortgage. I don't care about the interest on my proceeds, that's de minimis, but it's cost me $100 a day. This shouldn't have happened. And that's the discussion when a buyer asks for an assignment of funds that you need to have. Like, let's peel this a little bit just to find out how much it's gonna cost, because it is gonna cost us some. But no, it's not like it all falls apart, but things happen. You know, the lender doesn't like the way a buyer signed it, or the traveling notary didn't get a deed of trust signed, and they gotta go meet him the next day. You know, I mean, things happen. Very good. Guys, we did teach a CE and post-licensing class here in January or February on navigating the residential sales contract, so some of you may have already attended that. I did have some ask, and for everybody online, I am teaching that class again March 19th. You cannot get credit for both of them, but if you like the class, you can certainly attend the class. That's going to be actually, though, in the KW Metro Center Old Town office, but it's 2 hours on March 19th. Caveat, of course, being we will have to make the responsible decision in light of all this coronavirus stuff on whether we'll do that. But right now, fingers crossed, March 19th at 10 a.m. So, but that is everything on our discussion here today, right at about an hour. So appreciate everybody's time, and we'll certainly stick around if you have questions. And of course, you all know how to get in touch with us. Again, please don't hesitate. Reach out. Marta or Melody or I will be in that shop, and we look forward to seeing you at the settlement table. Carol.
I have a privilege. We can stop.
Very good. Turn that camera over that direction.